First District Court of Appeals now in session. All who have business before this court draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Thank you. You may be seated. Good afternoon. We have two cases on the docket today, and we will take them in the order that they appear. The first case is Tiburcio versus the Hillsborough County Sheriff's Office. Counsel for the appellant, you may proceed when you're ready.
Good afternoon, and may it please the court. My name is Amy de Guzman, and I represent the appellant, Ismael Tiburcio. I'd like to reserve 2 minutes for rebuttal.
So noted.
This court should reverse the decision of the JCC and find that Officer Tiburcio is entitled to workers' compensation benefits for 2 reasons. First, the JCC erred as a matter of law in interpreting the Section 112.18, 1B1 of the Florida statutes known as the reverse presumption. And second, there is no competent substantial evidence to support the judge's finding that Officer Tiburcio materially departed from a prescribed course of treatment resulting in his heart attack. In turning first to the de novo issue of statutory interpretation, this court should find that the reverse presumption requires the employer carrier to prove that the employee, the law enforcement officer, departed in a material fashion from a prescribed course of action or prescribed medication for the specific disease claimed. In this case, that would be coronary artery disease, and as documented in the prescribing physician's records. Here, the JCC erred on page 26 of the record when he, instead of requiring the employer carrier to prove that it was for the specific disease as claimed, instead inserted the risk factor analysis or risk factor management medications in determining that the employer carrier met its burden in reversing the presumption. This is a case of first impression, and therefore the statutory construction maxims of the plain language of the text and the supremacy of the text principle, along with the in para materiae maxim, should apply. Recently, this court in Vickers versus the City of Pensacola held that when the legislature uses specific words, it does so with an intent or with a specific meaning. In Vickers, the court held that this court cannot substitute the language that's in the statute, even if it results in a more reasonable construction.
Oh, go ahead.
I have one question based on a finding that the judge made below, excuse me, about the statute at issue. Just sort of it said it in passing, that the idea that the reverse presumption, as we call it, is for condition which has already been accepted as compensable, applies not to 1A, which is an issue here, but only to 1B. Is that an accurate description of how those two sub-paragraphs work? And maybe actually the first question is that the way that you would characterize what's going on here, that the exception only applies when the condition has already been accepted as compensable?
No, Your Honor. Subsection 1A is for an individual who has the condition but has not yet suffered a disability that would allow for an authorized treating physician to give an opinion, whereas subsection 1B is for the circumstance where an officer has a compensable claim, has an authorized treating physician, and then departs from a prescribed course of treatment for that condition that's already been compensable. In applying the distinction here, requiring the subsection 1A to be read with Part 2 of the statute, which is the definition of a prescribed course of treatment, it allows the JCCs to understand how to apply both rebutting the presumption and reversing the presumption. And that goes to the second point on the de novo issue of reading the statute as a whole or in para materiae. Because the language of the prescribed course of treatment says specific disease as claimed and in the prescribed physician's records, the only listed diseases in the statute are hypertension, heart disease, and tuberculosis.
So even if we agree with you on that point, that is, under the plain language of 1B, is limited by the definition in 2, which is the definition of prescribed course of treatment, I believe that JCC found, and perhaps the appellees will argue, that there is sufficient evidence in the record to show, the existence of heart disease, even if it wasn't formally diagnosed. There is language in one of the records that basically warned the claimant that if you don't do X, Y, and Z, you run the risk of, among other very serious complications, including heart attack.
Yes, Your Honor, the record, there was a record from Dr. Cheeseman, whose opinion is not admissible in front of the JCC. There was a record concerning that, but that exact question is why the court should reverse on the specific disease as claimed and as documented in the prescribing physician's records. Looking at those records for fact purposes only, he was not diagnosed with coronary artery disease until after his heart attack of February 14th, 2019. Even Dr. Nacero, the expert for the appellee, testified as such, that there was no obstructive coronary artery disease by objective medical findings prior to his February 14th, 2019 heart attack. In combining, when the legislature created this reverse presumption part of the statute, it did so at a time when this court had already decided cases involving risk factor management. It had already decided Punske versus Clay County Sheriff's Office, Fuller versus Okaloosa Correctional Institute, and other cases involving risk factors. And instead of expanding the application of the reverse presumption, it contracted it and put in the language of the specific disease as claimed. Instead of merely listing, a material departure from a prescribed course of treatment, leaving it at that, they went that further step to define a prescribed course of treatment. And based on that theory, the court should find that no word in the statute it should be interpreted meaningless, or it should be interpreted in a way that results in the statute being meaningless. And if this court were to affirm the judge's finding based on the language that the judge used in the order on page 26, it would make that prescribed course of treatment definition meaningless, because it would open up the door to allow the same risk factors, in this case that the judge rejected in rebutting the presumption, to spill over into the reverse presumption for any prescribed course of treatment.
So what, and I'm not sure what to make of this fact, but we know in the record that the claimant was a no-show, and certainly there's plenty of evidence that he did not follow up with the appointments as directed, and perhaps if he had, there could have been a more or an official diagnosis of heart disease, because we know we have all of these other risk factors that are in the record, and we have plenty of warnings that if you don't comply, you run the risk of a heart attack. And so maybe you can help me, kind of flesh out what, if any, significance should there be to the claimant, not following doctor's orders and going to the referrals, et cetera.
Yes, Your Honor, and that does bring me to the second point concerning the competent substantial evidence. First, briefly, there is no evidence that he didn't take his Brilinta, which is the only medication that was prescribed for his coronary artery disease. But to answer Your Honor's question, the records themselves are not as straightforward as the JCC put in his order. For example, he did go to a cardiologist prior to his heart attack. He was having chest pain and shortness of breath, and he didn't ignore that. He went and had an echocardiogram done in 2011 that the doctor at that time said that there was no obstructive coronary artery disease. And then 6 years later, he had chest pain, shortness of breath, and he went and got another echocardiogram. And Dr. Rodriguez said, again, no obstructive coronary artery disease. And in fact, in the echocardiogram report, the person who read it said, comparing to the 2011 echocardiogram, no significant changes. So he did follow up. He did go see a cardiologist, as opposed to someone who, was ignoring his chest pain or his shortness of breath. It would be unreasonable to require a claimant to just assume that he knows, what kind of disease he might have if the objective medical findings say that he does not have it. It wasn't until he had his heart attack, unfortunately, that it was diagnosed. I am sure that Officer Tiburcio would have preferred to have known that he had a blockage, an 85% blockage, before it got that bad, or a 30% blockage before it got that bad, but the echocardiogram just didn't show it.
But he did know that he was at, well, let's go into Dr. Cheeseman's records, and I know you don't believe that they're admissible, but he did know from those records that he was at risk for a heart attack, correct?
Yes, Your Honor. There was a record that said that if he did not comply with his medical treatment, it could develop into kidney disease, heart attack, or even death. I will say that the burden here is on the employer carrier to prove the reverse presumption, and Dr. Cheeseman was not deposed. We don't know if that language in that record was actually conveyed to Officer Tiburcio. He did testify at trial that he did not know that those medications were for his heart. He didn't know that it would cause him to have a heart attack if he didn't take it. That was his testimony at trial. So while the record itself says that, those records are very inconsistent. On page 1199 of the record, which is one of Dr. Cheeseman's record, it says that the judge relied on that record to say that he wasn't taking his blood pressure readings at home. But on that same record, it says medical compliance, yes. And the same thing on page 1247. It says, not taking his blood pressure at home, still smoking. But when it says medical compliance, when it comes to the actual issue, it says yes. So the records of Dr. Cheeseman are not as straightforward as they appear when you really look at it. And that's the foundation of both Dr. Mathias and Dr. Nassero's testimony. Additionally, under that competent substantial evidence issue, this court has held that a stacking of inferences is not enough to meet the competent substantial evidence standard in Inman versus Convergence leasing, employee leasing. And here, the JCC had to stack several inferences in order to have the employer carrier meet their burden of the reverse presumption. They had to determine that the medical records from Dr. Cheeseman, those pieces of medical advice for his cholesterol and his triglycerides were conveyed to him. And then also determine that the cholesterol medication and the triglyceride medication was somehow related to the heart disease that he did not yet have, that he didn't know he had. And that stacking of inferences is not competent substantial evidence to meet.
I don't know if I see the second part as a stacking of an inference. The first part I understand we're saying you have to infer that that Dr. Cheeseman related this information to your client, but the fact that failing to comply with hypertension treatment increases the risk of heart attack. I'm not really sure why it's an inference that necessarily arises from the first inferences. I don't see this as stacking.
It's a stacking in that the Dr. Cheeseman wasn't deposed as to what his position was on why he listed, what connection hypertension medications had for the ultimate disease as claimed here, which is the coronary artery disease. The JCC stacked that inference because Dr. Cheeseman wasn't deposed on the issue. Based on the language of the statute and the plain meaning of the word specific disease as claimed, and based on the fact that it needs to be in the prescribed doctor's records, this court should find that the JCC erred in interpreting section 112.181B, known as the reverse presumption, and that there's no competent substantial evidence that Officer Tiburcio departed from taking his Brilinta, the only medication for which was prescribed for his coronary artery disease. Thank you.
Thank you, counsel.
May it please the court, I'm Warren Sponsler, represent the Hillsborough County Sheriff's Office and Commercial Risk Management. The arguments set forth today will show that the judge did not err in his findings below, number one, and number two will also show that the claimant is unable to argue what they are arguing today, as it was not raised before the judge below. I'd like to start with the motion for rehearing that was entered by the judge, and Judge Ray, you touched on his order and some of the language in it in one of your questions earlier when you had brought up the question about previously compensated for compensable heart disease, and is that something that is required, and was that something that they were arguing, and they told you that they were not arguing that because that was subsection B, and they were actually arguing against subsection A, which was what we had argued at the court below and also in our brief. Interesting is, as Judge Massey points out in his order, at the time of the final hearing, they only argued two things as to why we were wrong. The first, as he states in his order, was that any noncompliance on the claimant's part was not willful or intentional, and the second was that the reverse presumption does not apply because the claimant was not previously compensated for compensable heart disease. At no point in time did they make the argument of what they are arguing today. The first time it came up was actually in the motion for rehearing. And in the motion for rehearing, which is found at the record, the order in the motion for rehearing, which is found in the record at 2983 to 2984, Judge Massey stated, and I quote, "Claimant argues the reverse presumption cannot apply because he had never actually been diagnosed with heart disease prior to February 14th, 2019, and therefore the prescribed course of treatment that I found the claimants who have been noncompliant with and to have materially departed from could not have been for heart disease, nor could it be legally or factually said." He goes on to state, first, the claimant did not raise this argument at trial or before trial and may not raise it for the first time on rehearing, citing Tacarte versus Florida Department of Health and Hyatt Regency West Shore versus Robinson, and goes on to state that the exact 2 points that they did argue were not the 2 points being argued in the rehearing, and we agree with Judge Massey that it was inappropriate to argue that for the first time on rehearing, and it seems to be that those are the only arguments that are being made today, and we believe that they are inappropriate as well. Second,
was the argument, and I unfortunately didn't print out that order, it's at my desk, but was the JCC making the point under B or under A? In other words, B requires compensation for heart disease, whereas A, I think according to the appellant's position, requires simply a diagnosis and a prescribed course of treatment for that diagnosis.
Right. So what he was indicating was that it was the position of the employer carrier at the time of the hearing that the reverse presumption section that was being argued by us was 112.181B1A, and that is the section that indicates heart disease or hypertension is presumed not to have occurred in the course of employment if the person departed in material fashion from the prescribed course of treatment of his or her personal physician. Of course, there's the other section that deals with departing in a material fashion from the authorized treating physician, and that was the section they argued below. They argued that this entire reverse presumption didn't apply because it only applied in instances where an individual was seeing an authorized treating physician and departed from the course of treatment. That wasn't our position below. Our position below was not following the advice of their personal physician, and the judge pointed that out in his order on rehearing, where he indicated now two different things are being argued that weren't argued before. And the reason I bring that up is because, one, you brought it up, and two, it seems to be the main argument on appeal today, and we don't believe it's appropriate because they didn't argue it below.
So let's, thank you for that clarification. Let's assume, for the purpose of my question, it was preserved. Do you agree that under A, a diagnosis in medical records is necessary, and in this case, a diagnosis for heart disease, and a failure to materially comply with a prescribed course of treatment for that heart disease is the appropriate way to interpret A?
First, to answer your question, I believe that there was a diagnosis of heart disease, as is indicated in many records of the physicians where they talk about his disease process, they talk about his atherosclerosis.
So let's get to that, if you don't mind.
Okay.
Secondary, do you agree that some sort of diagnosis in the medical records is necessary?
I agree, and I believe there is a diagnosis in the medical
Okay, and
records.
so that goes to a question that I asked the appellant, and that is kind of looking at the heart of the diagnosis. So where, can you point us record citations or language in the records that shows that there was a diagnosis for heart disease?
Sure. First of all, one thing I just wanted to clarify is appellants had mentioned that the issue was coronary artery disease and not heart disease. And I just wanted to be sure that the court was aware the claim was for heart disease, not coronary artery disease. That's the claim that was in the pretrial. That's also the claim that was in the final order of the judge, was for heart disease. There wasn't a specific claim for coronary artery disease, and I don't mean to be splitting hairs, but I thought it was important to point out since that seemed to be their argument. Second, to answer your specific question, Judge Ray, as far back as May 9th of 2011, pages 694 to 697 in the records from Dr. Rolando Rodriguez, he is diagnosed with atherosclerotic heart disease. Dr. Nacero, the independent medical examining physician, testified in his deposition, specifically in the record pages 1913 to 14, 1922 to 26, 1929 to 1930, that heart disease existed prior to the February 14th, 2019 incident, which was the heart attack and what we're here on before, and concluded that over the years, appellant materially departed from the prescribed course of treatment, and that this aggravated and worsened the already present heart disease.
So what was the prescribed course of treatment, though, for, and you can pronounce the word and I can't, Dr. Rodriguez's opinion on the thickening of the arteries?
It was the prescribed course of treatment was medications. The prescribed course of treatment was don't smoke. The prescribed course of treatment was various other things to reduce the risk factors. And I think that prescribed course of treatment and those things to reduce the ultimate probability that someone was going to have a heart attack are clearly stated in the records of Dr. Cheeseman, who came into the picture after that note from Dr. Rodriguez back in 2011. And the notes from Dr. Cheeseman are very clear when you go through them, and you referenced some of them in some of your questions earlier, where he talked to the claimant about the fact that he had been non-compliant with his medications. He had been non-compliant with following up at his office visits. He had been non-compliant about quitting smoking. And even states in one of the records, essentially, not using these words, but he essentially states he's a heart attack waiting to happen, and goes as far as to say, I've warned him over and over, he needs to do these things or he bears the risk of having a much worse condition, and even uses the words heart attack. And so he clearly told him, and it was clearly documented in the record, but the issue was Dr. Cheeseman deposed. I mean, his records were stipulated into evidence by both parties. The issue is there competent, substantial evidence supporting the judge's determination that there was this material departure from the course of treatment? And there clearly was. I could go through probably 7 years worth of records and talk about different things. I mean, I will mention a note from December 3rd of 2000.
Counsel, before you do that, well, go ahead, and then I'll ask.
Okay. Okay. There's a note from Dr. Cheeseman from December 3rd of 2012, and it states in his note that he told the patient it makes him very hard to manage him, and he runs the risk of complication from his disease. The disease is the heart disease, if it is not controlled. And then he instructed him to return in 6 weeks, and the records show he didn't come back for 9 months.
All right, I'll go ahead and ask it now then.
Okay.
One of the conditions under 112.18 is hypertension.
Correct.
It seems to me that what Officer Tiburcio was treated for was hypertension. And while that may be, well, it's related, it's to prevent heart attacks, it's to prevent heart disease, one could argue that what he was actually being treated for was something completely different, which is apparently what we're not here for today. They're not claiming that that he wants compensation for hypertension. Isn't there a difference between treatment for hypertension and treatment for heart disease that consists of controlling hypertension?
Absolutely, and I think he was treating for both. I think when you go through all over the records, it shows that he was treating for hypertension. He was treating for atherosclerotic heart disease. He was being treated for high cholesterol. He was being treated for diabetes. There was a laundry list of things that he was being treated for, not only hypertension and not only heart disease. And I believe that when you go through the records and look at them in their totality, it's pretty clear that he wasn't following the advice of his doctor and departed in a material fashion from what was being prescribed. And this is, continues to be replete throughout the records of Dr. Cheeseman. On May 16th, 2015, it's noted that he hadn't been taking his medications. He wasn't checking his blood pressure, wasn't taking his medications, stated that he was being non-compliant and was becoming very difficult to manage. February 15th, 2017, he didn't return for 20 months from his prior visit, had been out of all medications except his diabetic medication, ironically. Also noted in that note, and this is very important, that he hadn't seen any doctors since he had been last seen 20 months before. And I believe that's important because appellant points out in their brief that he was getting treatment somewhere else and at the VA, and obviously that doesn't appear to be the case. And when you put all of this together, it's very clear that, number one, he clearly departed in a material fashion from the prescribed course of treatment of his physician, and number two, there's clearly competent substantial evidence in the order supporting Judge Massey's finding in that regard. And I believe that covers all the issues if there are no further questions.
No, thank you, counsel.
Thank you. I don't usually finish early. Thank you.
May it please the Court, first addressing the appellee's argument concerning the relevance or the ability to bring this argument. It was argued below. There was a lot of concern about what the defense was. It was found on page 114 of the trial transcript prior to the judge's order. Additionally, the final compensation order is the record, or is the order that's on appeal here. Turning more to the substantive issues, the early atherosclerotic changes, which is what the appellee is kind of relying on in saying that there was the existence of heart disease, is not, nobody testified to that. No, Dr. Nacero didn't testify to this. Dr. Mathias didn't testify that this early atherosclerotic change resulted in any kind of, or was any kind of coronary artery disease at the time in 2011. What was clear and what was testified to was that Dr. Nacero testified that there was no objective medical evidence of coronary artery disease prior to his heart attack. That is in the record. He testified there was no evidence of coronary artery disease before he had his heart attack event. It's not in the assessment portion of the medical records. It's not in the active problems list of the medical records. He was not diagnosed with it until his event. And at that point, he was prescribed medication specifically for the disease claimed, which is the Brilinta dual platelet medication, Brilinta and aspirin, that Dr. Nacero testified to, and Robert Medina, the 120-day physician, in his record said was specifically for the treatment of his coronary artery disease. In reversing the court's decision, this court would be in line with the plain language of the statute and would further legislative intent of this public policy presumption. And for these reasons, this court should reverse. Thank you.
Thank you. Okay, thank you to both counsel for your excellent presentations. Take your time leaving the podium. Excuse me. may approach when you're ready. Okay, our second case and last case on the docket today is Francis versus the City of Tampa, case number 21-1947. Counsel for the appellant, you may proceed when you're ready.
My name is Nicolette Sambus. I represent the appellant, Mr. Mark Francis. In this matter, I'd like to reserve 4 minutes for rebuttal, please. This is a case of human cruelty, and I say that not to exaggerate. I say that in a means of where we have an individual, Mr. Mark Francis, who is a first responder. He had an industrial accident, a very severe industrial accident in 1994. This is a long-standing industrial accident the claimant had. It's important to present the history and the understanding of who this claimant is before we actually go into the issues that we're here about. We're here about what happened to Mr. Francis, who had a 1994 accident, had a failed back surgery, underwent treatment to try to recover from this, ended up in chronic pain management. He went through detox, according to the record, twice. This is unsuccessful detox. He ends up going back onto the heavy narcotic opioids that were actually the cause of the catalyst of what brought us here today. So Mr. Francis is an addict, a narcotic addict created by the workers' compensation system, created by a work-related injury. It's important to note that he was with Dr. Cromer. After completing a detox program, his pain tolerance increased, which led to the higher increase of opioids. And we know during this period of time from 1994 to 2021, which is the period that we're talking about here, the system with regards to pain management and the prescription of these medications has obviously changed with the facility who controls the medications, I guess the CDC. But
Counsel, we understand all those things, and we appreciate that background. But what do we do with the statute, or actually the statutory sections at issue here? And we have what appears to be serial misleading statements by your client to get more benefits, i.e., to get more medication. I just don't know how we avoid the conclusion that the JCC reached in that regard. Because isn't that the essence of why we're here?
Yeah, that's the issue. There's two issues here. There's the issue of the JCC's error we take as a matter of law by failing to consider the claimant's intent. And when you consider the claimant's intent, you have to look at the claimant, the subjective nature of the claimant. And that's why I go through the history of who this claimant is, of who Mr. Mark Francis is because his intent. You can't judge Mr. Francis, or the JCC should not have and erred accordingly by judging him as a reasonable person or judging him by the judge's standpoint. You need to look at Mr. Francis as
let's look at the
as an
statute.
addict.
And excuse me, it says it shall be unlawful for any person. I'm under 440-105, and the language to knowingly make any false, fraudulent, or misleading oral or written statement for the purpose of obtaining any benefit or payment under this chapter. How can you say, though, based on that background, that he didn't knowingly make these misleading statements? I mean, he wrote 2 letters and provided all this testimony. The standard is knowingly. How did he not knowingly do it?
The claimant made statements regarding his prescription medication that he was getting legally, that he was getting from his authorized treating provider, Dr. Cromer. He was out of medication. That's not in dispute. I mean, he was out of medication. When Dr. Cromer could no longer see the claimant, he was now sent into a spiral, right? So he no longer is able to get medication legally. Now, yes, he had this medication from an emergency supply, and yes, that is in the record that it was quite a lot of medication. I believe that, according to the judge's calculation, over 2,000 pills placed in a large Aleve bottle. But the issue is, from the claimant's perspective, was it his intent? And that's where this is where the claimant is taking the position that there was the error with the judge, is that was it his intent to obtain workers' compensation benefits by saying that he was running out of legal medication. I mean, the word legal is, I guess, where there's a dispute. 'Cause-
Go ahead.
I'm sorry. I seem to recall the JCC mentioning that your client on at least a couple of occasions mentioned that if he did not get more medication, that he may go into withdrawal, and that fact is belied by this so-called emergency supply.
Well, does an individual like like Mr. Francis want to use illegal means to further his addiction?
Maybe not, but it seems like the
Right.
JCC believed that by saying, I will go into withdrawal if I don't get this medication, that statement is false, given that he had this emergency supply of medication.
Well, that's the issue of where there's two elements, right? There's the false statement, that's number one, and then you go to the intent. And that's where the case law is clear with the Markham decision and various other decisions where you have to be considering the subjective intent of the individual. And so we're talking about Mr. Francis and the statements that he made with regards to his medication, but then there's a second element to this case that also needs to be considered and is also the reason why we're here with regards to the manipulation of the system by the employer carrier and what caused the spiral of Mr. Francis, a permanently totally disabled individual who has been in the system and receiving chronic narcotic medications for over 15 years. He's on these medications. Dr. Cromer is his established treatment plan, and then all of a sudden, now that Dr. Cromer can no longer treat the claimant, the employer carrier gets to get excited with their plan, and they get to switch the claimant's treatment plan. They sent him to a doctor, Dr. Balani, who knowingly could not prescribe and would not prescribe him the current treatment plan that he was on. Now,
That's what you're making, the argument you're making now is the unclean hands defense?
I'm getting there, yes.
Okay. And I have several questions about that defense. Do you have any cases from this court or the Florida Supreme Court saying that unclean hands applies in a workers' compensation case?
Your Honor, no, I don't have, there isn't any that says that it does not apply. The judge of compensation.
So the answer is no, you do not have any cases saying it does apply, correct?
Or that it does not apply.
Well, and that's the bigger issue, at least for this judge. As I read the powers and duties and authority of the JCC, I don't see there's an equity power. Is there something in the statute I'm missing that gives equity power
Your
to
Honor,
the JCC?
Well, I'm sorry to interrupt, but yes, Your Honor, I believe that 44033 that gives the judges all powers to do all things conformable with law. This is important to note. You can't have, in a system where it's essentially a dictatorship system with the employer carriers, where there are very few checks and balances as is, in a system where the Chapter 440-105 specifically states that it's any person cannot knowingly make or cause to be made false statements for the purpose of obtaining or denying any benefit or payment. So that specific from the legislator implies that the employer carrier is supposed to be held responsible, but if you don't allow a judge of compensation claims to have any enforcement or any ability to even check and balance the system, then you're faced with a situation where a claimant is held strictly liable and strictly accountable for any type of statement or wrongdoing or potentially misinterpretation of his actions, where the employer carriers don't have any responsibility.
You referenced, and thank you, 44033, I've got it up here. It says, and do all things conformable to law. Well, equity is not law. So that wouldn't apply, would it?
I believe that it is a form of law. It's not a statutory construction position, but it is a mechanism for the courts to assess fairness, assess reasonableness. And it's not necessarily even going to the words unclean hands doctrine. It's going to the fact of when there are misrepresentations for the employer carrier, or there are actions that have essentially tied the claimant into into a noose. I mean, they dug him a hole, and he went down a rabbit hole because he was now being forced to do certain actions, and the employer carrier, based on the record, even with the testimony of Dr. Kaplan, tainted the physician's testimony, and nothing can be done about it because the judge of compensation claims says he doesn't have to do anything, or he doesn't have the authority, and he cites the MacArthur decision. And I think what's important to distinguish with the MacArthur decision is that that was a case where the claimant filed a petition for benefits seeking to assess wrongdoing from the employer carrier based on 440-105. In this case, the claimant is not filing a petition for benefit or a petition seeking that specific remedy. This is a case where there is wrongdoing, and I understand that two wrongs don't make a right, but it goes back to the fact that when one party is he's deprived of his property right, he loses. Mr. Francis lost his entitlement to permanent total disability benefits, lost all entitlement to medical benefits for a long-standing, very serious injury where he was, and essentially a system that created him, created his addiction, created his need for further medication, and sent him down this hole where essentially he was found to be taken, where all of his rights were taken away. I'm getting close to my rebuttal time, but if there's any other questions, I can answer them before I...
Well, I did, and I'll extend the time if needed, but I did want to ask you about your challenge regarding the burden for the misrepresentation claim and your contention that it should be a higher burden of clear and convincing evidence. I mean, certainly our court has already decided this issue. Do you disagree?
Well, no, I've read those decisions, yes,
right.
and I repeatedly bring this up.
Right.
I filed this. There's the system in practice is that with such a weak standard or burden of proof, the preponderance of the evidence standard, it sends the employer carriers into feeding frenzies against these claimants and these injured workers who any misstep, any just a statement in passing can be taken against them, and now all of a sudden they're fraud or they're fraudulent or there's misrepresentations being attacked against them. So I do understand that the standard is preponderance of the evidence, but I do believe that the appropriate standard should be clear and convincing evidence because this is a forfeiture of a property right. It's been clearly determined in other cases that workers' compensation benefits is a property right. This is a right for his economic well-being, for his medical care, and now it's entirely taken away from him, and that's taken away from him, but the employer carrier has no responsibility. And so that's why we would ask that it just be reversed and remanded for more determination as to the assessment of proper wrongdoing.
Okay, thank you, counsel. Madam Clerk, would you please add 2 minutes to appellant counsel's time, and we'll please extend appellee's time accordingly?
May it please the court. Hello again, I'm Warren Sponsler representing the City of Tampa and Commercial Risk Management. First, let me just state that although Mr. Francis clearly had a serious injury, this isn't a case about human cruelty. This isn't a case about manipulation by the employer carrier. This is a case about someone who lied and took any step they could do to obtain massive amounts of OxyContin and medications, lied under oath in various judicial proceedings, and in order to get those medications. That's what this is about. There's no evidence from any psychiatrist or anything else that he didn't know what he was doing or any of those things. That's not anywhere in this record. And it's interesting because in this case, normally you have the situation in these cases involving the misrepresentation statutes 440-105 and Florida statutes 440-09, where someone is lying with the intent to get workers' compensation benefits. In this case, not only did the appellant lie with the intent to get workers' compensation benefits, he got workers' compensation benefits. There were 2 emergency hearings that are cited throughout the briefs that took place before 2 different judges of compensation claims, where he said he was going to be in withdrawal and in the emergency room and become very, very sick because he had no more medications. It wasn't no more legal medications. And even if that is what he meant, it's still a lie, because he obviously wasn't going to be very sick and in the hospital from withdrawals. And in one of those hearings, the judge ordered us to call the doctor that had sold his practice and do whatever we could do in order to get him to give him one more refill until he saw the other doctors. And we did that. That's exactly what the employer carrier did. I won't tell you how they did it because it's not part of the record, but that's what they did, and the doctor prescribed him more. Then he went to another hearing and said to the judge, I'm going to be in the emergency room tomorrow morning if you don't give me these pills. And what was going on here, and I think Judge Massey addressed this pretty clearly before he was recused from the case at the request of the appellant, and then Judge Arthur came into the case. But what Judge Massey said in multiple hearings is, I can't force doctors to prescribe the amounts of medications you want. And this isn't about Dr. Bellani. Dr. Flynn had been authorized. Dr. Cruz had been authorized. Dr. Bellani had been authorized. None of them would prescribe the massive doses of OxyContin that he was on. They said it wasn't within FDA compliance, and they wouldn't do it. Were they allowed to prescribe the medication? Yes. In fact, Dr. Bellani did prescribe it at a lower dose, not the dose that he was taking. And he became upset and wasn't satisfied with that. So what happened instead is there were multiple misrepresentations over and over and over. Now, no one really knew about these misrepresentations until he started visiting some of the doctors. And that's when one of the doctors did a blood test and said, well, how can all this be in your system? Was Dr. Cruz. How can all this be in your system if you ran out of it? And then he made the statement to her, oh, well, it's legal, but I don't want to talk about it. Dr. Flynn, he told him that he had some leftover OxyContin at home. He says, bring it in, let's do a pill count. He brings in 21 pills. The evidence shows that he had thousands of pills when he came to Dr. Flynn and said, I only have 21. The evidence shows that he had thousands of pills when he testified in front of Judge Young that he had no more medication.
What is the evidence that he had thousands of pills?
It's in the final order, and it actually...
I see it in the order.
Right.
What is the evidence that at any one time he had thousands of pills?
It came from his testimony. Initially, he had indicated that he had invoked the Fifth Amendment and wouldn't answer any questions about where that had come from. Then at the time of the final hearing, he no longer invoked the Fifth Amendment and testified that he had been taking 5 or 6 pills a day and had continuously taken 5 or 6 pills a day since he last saw Dr. Cromer, which had been a couple of years before. And doing the math, it was obviously thousands of pills that he was taking. He also testified...
so he took thousands of pills, but there's no evidence that he ever had at any one time thousands of pills?
There is. In the final hearing, he also testified that he got the pills when he was getting out of rehab and bought them from another patient at the rehab, and that he had thousands of pills, and the judge even questioned him, well, how could that fit in an Advil bottle? Because he said that he had all the pills in an Advil bottle, and at the hearing he ultimately testified, well, no, it was more like a box than an Advil bottle. And, he called this his emergency supply, but this was more than an emergency supply. It was thousands and thousands of pills that he had access to and continuously lied about when he was before multiple judges, as well as in deposition, as well as to doctors that he had seen. And I think it's pretty clear based on how the judge ruled. Now, what the appellant is asking you to do is, instead of look at 44105 and 44009 and agree, as you said, Judge Jay, I mean, it looked pretty clear that he had made these misrepresentations. They're asking you to qualify the defense and somehow say, well, you have to look at the totality of the circumstances. That was their argument in their brief. You have to look at how injured he was. You have to look at the system that this went through. That's completely irrelevant in determining whether somebody violated Florida statutes 44105 or 44009. The issue is, did they make a false statement? There's no question false statements were made. I could spend a lot of time going through all of them, but I think you're probably already familiar with most of them. And did he do it with the intent to get workers' compensation benefits? And he clearly did. Not only did he do it with the intent to get workers' compensation benefits, as I stated, he got workers' compensation benefits. from his false, fraudulent, and misleading statements. And that's why Judge Arthur ultimately denied the case and indicated he couldn't have any further workers' compensation benefits. Now, I would like to address this whole issue of the unclean hands and how this somehow means that you don't look at the fraud defense, and that that the unclean hands issue and the unclean hands doctrine means that none of this should have ever happened. First of all, as you pointed out, Judge Jay, there is not one case anywhere indicating that this applies to workers' compensation. Number two, it wasn't even raised at the hearing below, and the judge notes that in his final order. You know, after the deposition of Dr. Kaplan, they had filed a motion to strike the employer carrier's defenses. Never mentioned unclean hands. If they thought it was an issue, they could have mentioned it then, but they didn't. And then at the final hearing, again, it wasn't mentioned. It wasn't mentioned in their trial memorandum that was filed 48 hours before the final hearing. It was mentioned after the fact, and that's what the judge stated in his order, that they never raised this. They didn't raise it until the close of evidence. It came in the form of a motion for rehearing and wasn't something that he was going to entertain. Number two, even if it was raised timely, even if everyone knew about this, there's no evidence of any unclean hands. The entire argument of unclean hands involves whether Dr. Kaplan was qualified to serve as render treatment as an addictionologist, which had been recommended by Dr. Cruz. Now, this was going on before the case had been denied for misrepresentation and before that had been alleged. So at the time it was an issue, and those were some of the issues that the judge heard at the final hearing as well that they did not appeal his denial of. But what had happened was Dr. Cruz recommended that he be seen by an addictionologist. And so an appointment was arranged with Dr. Kaplan, and the record is replete with emails between appellant's counsel and appellee's counsel where they said, well, what makes him qualified to do that? And so the CV was sent over. Still wouldn't let him go see him. Then Dr. Cruz sent something out that said what she meant was a psychiatrist that specializes in addiction. That's what Dr. Kaplan was. Still wouldn't let, the appellant still wouldn't go and see him. Again, this was before the case was denied. And they clearly questioned his qualifications. In fact, in their brief, they even go so far as to state, as part of this whole manipulation and taking advantage of the appellant, they go so far as to state that the appellant offered physicians that weren't qualified. They state in their brief. And that's exactly what they were saying with Dr. Kaplan. He's not qualified to do this. The only reason his deposition was taken was to show that he was qualified to do this in the event that the judge found that he was going to grant their claim for the addiction specialist, because there has to be evidence that he's qualified, and that's why it was taken. There's certainly no evidence of any unclean hands or overreaching, and to the contrary, I think the evidence shows that the employer carrier literally jumped through hoops to provide him with medical treatment through the multiple doctors they authorized after Dr. Cromer retired or sold his practice or whatever happened to where he could no longer see him. And for all of these reasons, we believe that the order below should be affirmed. Thank you.
Thank you, counsel.
May it please the court. I'm just going to point out a few issues that I had with counsel's arguments, just the inconsistencies that are in the record. I didn't see anywhere in the record where Dr. Bellani actually prescribed the claimant medication. He gave him a list of 3 options that he could do to get down from the amount of medication that he was taking to get to a point of where he would offer treatment to the claimant. So it's not a matter of where Dr. Bellani was like, okay, I'll give you some meds, we'll wean you down. It was like, here are your 3 options. You can go to a detox program, you can do it yourself, or you can cut them down and then get to your amount that I would be willing to treat you at. So that was the first issue. And then, there's a reference to massive amount of narcotic medications. Well, that was massive amounts of narcotic medications that the workers' comp carrier was providing to the injured worker. They got him to that point over 15 years. He was getting those medications. That was his plan of treatment. And they referenced that there's no psychotic or psychiatric condition in the record. Well, there is. When on page 254 of the record with a prior final order from the judge of compensation claims where he was adjudicated permanently and totally disabled, it is clear he was treating with Dr. Pandia from a psychiatric standpoint, and the working diagnosis that is accepted by the court, it is the operation of law, is that he has major depressive disorder, pain disorder, dependency on narcotics. This is going back all the way to 2010. Personality disorder with severe narcissistic paranoid features. This is the individual that we're here about. This is the individual that the judge of compensation claims had to sit in the shoes of. I don't like to quote, and I don't want to be cliche, but I think it's important to quote Atticus Finch here, where Atticus Finch says, "You never really understand a person until you consider things from their point of view," and then he goes on to put the skin on and walk in their shoes. Well, that's what the misrepresentation defense is, Section 105. So that the judge erred as a matter of law by failing to consider the intent, the specific intent of the subjective intent of Mr. Francis. So that's important to note. And then I also want to note that the statute is clear that the employer carrier cannot de facto deauthorize a physician, and I believe that analysis goes to de facto deauthorizing the treatment plan that an individual was receiving. Here, they were providing Mr. Francis with 15 years of chronic heavy narcotic medications, creating an opioid-dependent individual through the workers' compensation system. That is his treatment regimen. Now, that is what they were supposed to authorize when Dr. Cromer is no longer able to provide that care. The Marine Max versus Blair decision from 2019 that's actually cited by the employer carrier in their brief talks about specifically, I left my case law over there, but talks about specifically that you cannot de facto deauthorize a physician. The employer carrier is responsible for providing that same treatment regimen unless there's some type of utilization review and a finding from the court. Well, they send the claimant to Dr. Belani knowing that he is not going to provide that same treatment plan. They get a windfall, because they're no longer going to have to prescribe these narcotic medications for the individual. They send the claimant to Dr. Belani, who's not going to provide that. Well, the claimant, as a narcotic addict created by the system, that's not going to work for him. He's already been through detox twice, and it was difficult from his psychiatric standpoint, from his subjective standpoint, to accept that. So what happens? He asks for a one-time change in physicians. He goes to Dr. Flynn. Dr. Flynn was about to provide the treatment, but then retires. So they send the claimant to Dr. Cruz. Dr. Cruz, again, a physician who is not willing to provide that same treatment plan that he is supposed to receive in the system. So Dr. Cruz refers the claimants to the addictionologist. Counsel refers to an addiction specialist. There is a difference. There is a clear difference, and Dr. Kaplan testified to that. Although he was extremely aggressive with counsel in the deposition in the beginning because of the tainted assessment that the physician thought he was being attacked for his qualifications, it wasn't attacking him for his qualifications. It was attacking him, or not even attacking him, but he wasn't the specialist. He wasn't going to be able to prescribe even the Suboxone to get him off of his narcotic medications. I respectfully request this court to reverse and remand the decision back to the lower court. Thank you.
Thank you, counsel. Thank you, both counsel, for your arguments today. The court is now adjourned.
All rise.